Offense of defamation. It is defined in Section 499 of the Indian Penal Code. The bare language of this section is whoever by words either spoken or intended to be read or by sign or by visible representations make or publishes any imputation concerning any person intending to harm or knowing or having reason to believe that such imputation will harm the reputation of such person is set except in the case hereinafter expected to defame the person. This is the bare language of section 499. ये धारा 499 इंडियन पिनल कोड में एक्सप्लेन की गई है, जिसमें डिफामेशन के बारे में प्रोविजंस हैं। मेन जो इसमें इंग्रेडिएंट्स हैं वो डिफेम है। इस पर्टिकुलर ऑफेंस में एनी पर्सन हु डिफेम द अनदर इज लायबल फॉर द ऑफेंस ऑफ डिफामेशन। देयर इज 10 exceptions of this section which would be discussed after that. इसे हम बाद में बात करेंगे। जो इंग्लिश लॉ है वो आपने पढ़ा होगा इन लॉ ऑफ आर्ट। द इंग्लिश लॉ ऑफ डिफामेशन इज डिवाइडेड इनटू लाइबल एंड स्लैंडर, बट अंडर इंडियन पेनल कोड डिफामेशन इज एन ऑफेंस without any reference to its tendency to cause act of illegal violence. Mental suffering caused to the person defamed is the gist of this offense. Here under Indian law, there is no distinction between libel and slander. What is the ingredient of this section? The section requires 3 essential. Number 1, making or publishing any imputation concerning any person. Second one, दूसरा, such imputation must have been made by A. words either spoken or intended to be read or sign or visible representations. The third ingredient of defamation is such imputation was made with the intention of harming or with knowledge or reason to believe that it will harm the reputation of the person concerning to whom it is made. This is the ingredient. What explanation says? Explanation 1 says, it may amount to defamation to impute anything to a deceased person if the imputation would harm the reputation of that person if living and is intended to be hurtful to the feeling of his family or other relatives. इस एक्सप्लेनेशन में एक्सप्लेन किया गया है कि जो पर्सन है जिसकी डेथ हो जाती है, जो डेड है, उसकी डिफामेशन हो सकती है या नहीं हो सकती है। एक्सप्लेनेशन 2 क्या कहता है? एक्सप्लेनेशन 2 कहता है, इट मे अमाउंट टू डिफामेशन टू मेक एन इम्प्यूटेशन कंसर्निंग ए कंपनी और एन एसोसिएशन और कलेक्शन ऑफ पर्सन एज सच। इसका मतलब ये है, इसका सिर्फ ये मतलब है कि कंपनीज और एसोसिएशंस और ग्रुप्स ऑफ पर्सन के भी डिफामेशन किए जा सकते हैं। Explanation 3 says an imputation in the form of an alteration or expressed ironically may amount to defamation. कोई भी इस तरह के जेस्चर वगैरह बना करके भी कोई क्रिएचर क्रिएट करके भी आप किसी की डिफामेशन कर सकते हैं। एक्सप्लेनेशन 4 क्या कहता है? नो इम्प्यूटेशन इज सेड टू हार्म ए पर्सनस रेपुटेशन unless that imputation directly or indirectly is the estimation of others, lowers the morals or intellectual character of that person, or lowers the character of that person in respect of his caste or of his calling, or lowers the credit of that person, or causes it to be believed that the body of that person is in a loathsome state, or in a state generally considered as disgraceful. This is the explanations. So we now read, explains these explanation and basic ingredients of defamation. The first ingredient is, I have earlier discussed in this PPT, makes or publish any imputation concerning any person. Every person who is engaged in composing, writing, dictating, or any other way contributing to making of a libel is the maker of libel. Where the matter is dictated by one person and it is written by another person, the both persons shall be guilty of the offense of defamation. Similarly, if one person speaks, another writes, and third person approved it, all three shall be guilty. The reason is that all who concur and assent to doing of unlawful act will be guilty of offense. In ingredient 1, there is a point, publication of defamatory matter. For the offense of defamation, publication of defamatory matter is essential. In other words, the defamatory matter must be communicated to some other person, the person to whom it concerns. For example, dictating to a letter to a clerk to write, it is publication. Where the defamatory matter is communicated to the person defamed, such a communication will not amount to publication. In case of Taqi Hussain, a person depasted the public officer a notice by post which was closed in a cover. The notice contained imputation on the character of the recipient. Allahabad High Court said, since there was no publication, therefore this offense was not constituted. There are so many cases. I have want to discuss someone. In a case, a person wrote on a piece of paper some abusive matter touching to the honor and reputation of another and posted it to the latter in a registered envelope marked personal on the uh, cover page of envelope. B, on receiving it, read the content and wrote the counter abusive language about A on the reverse of the same paper and said it back to him in another envelope by ordinary post. The envelope, however, opened at its destination by C, who read the whole matter written by both A and B against each other. What is who said defamation? किसने किया? In this case, neither A nor B will be liable for defamation. क्यों? Because there was no publication of defamatory matter, and it will not make a difference whether the letter containing scandalous matter were sent by registered or ordinary post, because in these cases, in both the cases, they were the letter was addressed to the persons concerned. Now, the case of K.V. Ramesh and H.S. Ramesh, K.V. Ramesh versus H.C. Ramesh. Sorry. A newspaper published extract from a book about the former Prime Minister of India alleging corruption. The extract also contained imputation against his wife, son, and daughters, held that the son could be held to be a aggrieved party, and therefore the complaint filed by them cannot be quashed. The editor of newspaper was held liable under this section of Indian Penal Code. There are, however, certain communication which, if made in ordinary course of business, do not amount to publication because they are intended in the category of privileged communication. Means जब कोई privileged communication करता है तो उससे defamation नहीं होता. Hence a person exercising the privileges may communicate matters to a third person in the ordinary course of business, and he would escape penalty provided for this offense. Now, another case, N.L. Shah versus Patel Magan Bhai Rewa Bhai. This is the case of Gujarat. It is here an interesting situation arose for this decision. There was an agitation by lawyers in Gujarat in connection with the appointment and transfer of the judges of High Court. On account of the agitation, the lawyers ceased to participate in court proceedings and restored to Satyagraha. An editorial in a newspaper criticized the lawyers and said they are Kajia Dalal, means they are dispute brokers. In the editorial, in a suit for defamation against the editor of the newspaper, the Gujarat High Court held that the editorial did not refer to the complainant personally or to any other individual, but referred to the liars as a class and at the most of liar of Gujarat. The alleged defamation could not be referred to determine or identifiable section or class of liars as distinguished from the rest of members of liars fraternity. The word Kajia Dalal was held to be used in relation to the lawyers as a class and is not referable to a determinate section of lawyers, namely the lawyers who were participating in the agitation. The thrust of the editorial was that lawyers should not have gone to strike If the imputation is defamatory per se, necessary mens rea will be presumed. The maker of the statement must know that it will harm the reputation of one concerning whom is made. The court in this case distinguishes between character and reputation. The term reputation means what is generally said or believed about the person or things, and character means fortitude or moral constitution or strength of a person. It has no relevance with the belief or opinion of others in respect of a person. Therefore, character is what a person actually is, while reputation is what neighbors and others say what he is. The man may have, in fact, a good character and yet suffers from bad reputation or vice versa. By no stretch of reasoning, the term reputation can imply one's own belief about himself. What is the reputation? Under the Act, no distinction has been recognized in the defamation, whether published for the first time or repeated subsequently. A publisher shall be strictly responsible for publishing a defamatory matter, irrespective of the fact whether he is the originator of the libel or is merely repeating it. What about the newspaper? Publication of defamatory matters in newspaper. In newspaper stands in matter of defamation in the same position as member of the public in general. The publisher of newspaper shall be responsible for defamatory matter published in his newspaper, whether he was aware of that or not. But an editor's position is somewhat different. He can escape his liability by proving that defamatory matter was published in his absence and without the knowledge, and he has in good faith entrusting the temporary management of the newspaper during his absence to a competent person. The owner of the paper or general, however, as a owner, has no responsibility. The publication of a notice in a newspaper conveying an imputation that the complainant is dishonest in the management of the affairs of the company and thus to concern the dishonesty dishonesty by method that are themselves dishonest to defamation. In Ashok Kumar Jain versus State of Maharashtra, it was held that whether a defamatory statement against a person is published in newspaper, the editor, printer and publisher who has made declaration and is shown in paper as such is liable, where it is alleged that the chairman of board of director of company and its general manager took part in selling out newspaper. It is indicative of the fact that they had prior knowledge of defamatory matter in paper which they could prevent, but did not do so. They would guilty of the offense and liable under section 499 and section 502 of the Indian Penal Code. Students, you read the case Satrugna Prasad Sinha versus Raj Babu Suraj Malrathi. It is discussed in your textbook. It belongs defamatory A statement which is published in a film magazine Stardust about some defamatory statement about the Marwari community. Now, another case, S. Khushbu versus कार्नियामल, ये भी आप इसमें से डिस्कस कर लीजिएगा। अब मैं एक और केस आपको डिस्कस कर देता हूँ, ए विजयकांत वर्सेस पब्लिक प्रोसिक्यूटर धर्मपुरी डिस्ट्रिक्ट इज एंड अदर्स. दिस इज द case of 2017. It is observed that though constitutional validity of criminal defamation under Section 499 and Section 500 of IPC has been upheld by the apex court in Subramaniam Swamy versus Union of India, yet it is being contended that these provisions are being misused to muzzle criticism of government, and there are malpractices also by abuse of office by public prosecutors who are using these provisions in a routine manner to harass citizens. The crucial question that arises is that whether the authority who is entitled to launch prosecution under Section 499 and 500 IPC through the public prosecutor should do it against a person solely because he is critical or has different opinion that of government.
The word imputation used in section 499. The imputation should have been made by words either spoken or intended to be read by sign or by visible representation. In India, a person can be defamed not only by writing but by spoken words also. Here at this point, Indian law of defamation is differed from English law. Under English law, only defamation, writing, printing, or some other process only constitute defamation. Spoken words never constitute defamation. Under that law, means Indian law, spoken words furnish grounds for a civil action. In Indian Penal Code, the words also furnished grounds for civil action. In Indian Penal Code, the word defamation has been used to denote what is known as libel and slander under English law. The word visible representation will includes every possible form of defamation which ingenuity can devise. Thus institutes a caricature, an effigy, chalk marks, signs, or pictures may constitute a libel. In addition to word spoken, the publication of a group photograph with a false captions would be defamatory. The word used here in 499 is intending to harm or knowing or having reason to believe that such imputation will harm. It means there must be an intention to harm the reputation of the complainant or the knowledge that the imputation will harm the reputation of such person. It is not necessary that actual harm should result. The test to determine whether any statement is defamatory or not is whether under the circumstances in which This is published, a person of reasonable prudence to whom publication was made would be likely to understand it is a libelous sense. Thus, when certain article published in a paper containing scandalous accusation against the girls student of a college which implied that the girls were habitually guilty of misbehavior described in the article. Each girl thereby individually suffered in reputation, and hence some of girls were held entitled to maintain action for defamation. Now, what is the defamatory article? In MP Narayan Pillai versus MP Chako. In this case, it was held that when, where an article is published in many parts and some containing defamatory materials, other is not. In such a case, article as a whole must be read. Means the impact and effect of imputation has to be considered in the background of entire facts and circumstances which is stated in the published material. If the disreputable part can be removed by the other part and the conclusions, then no prosecutions for defamation can be launched by picking and choosing the disreputable part alone. The circumstances under which and the portion of the article wherein the alleged defamatory imputation occurs and their impact on the mind of the readers are reading the article as a whole has to be considered. Now come to the explanation 1, which I have earlier read. These exceptions will come into operation when there is two situations. Number 1, the imputation would have hurt the deceased reputation, and number 2, it would also have hurt the feeling of his family and relatives. A suit was brought by the heirs and nearest relations of the deceased person for defamatory words spoken of such deceased person but alleged to have caused damage to the plaintiff as member of the same family. It was held that the suit was not maintainable. Now, explanation 2. An action for libel will lie at the suit of an incorporated trading company in respect of a defamation calculated to injure its reputation in the way of its business. A corporation has no reputation apart from its property or trade. It cannot maintain an action for defamation merely affecting personal reputation. This exception covers any collection of person, but such collection of person must be identifiable in the sense that one could certainly say that this group of particular peoples has been defamed as distinguished from the rest of the community. The case of MP Narayan Pillai versus MP Chaco is important here. Explanation 3. A statement innocent in form or in form of an alternative will amount to defamation if it is ironical. Now explanation 4. This exception makes it clear that the term referred to the referred to in the explanation has reference to imputations on a man's characters made to lower him in the estimation of the other and not by himself, thus describing a woman that she is paramours wherever she goes is per se defamatory. An imputation that a person would be excommunicated if he carries on the business of leather and he is participated in social functions and takes meals in certainly one which lowers the moral character of that person not only by itself but also in respect of his profession or business of leathers. Now, let's talk about the exceptions. Exceptions 1 means exceptions says imputation of truth which public goods requires to be made or published. This is the heading of Bear provisions. And what the Bear says, it is not defamation to impute anything which is true concerning any person, if it be for the public good that the imputation should be made or published, whether or not it is for the public good is a question of fact. This is the first exception. The requirement of these exceptions are number one, that the impugned statement must be shown to be true. This is the defense. And number two, its publication must be shown to be for public good. This exception and exceptions 4 required, which I have discussed later, this exception and exception 4 requires that imputation should be true. The remaining exceptions do not require it to be so, they require that it should be made in good faith. It is also necessary that truth, when set up as a defense, must extend to the entire defamation and not only to a part of its. Now, no amount of truth will justify a libel unless it is established that its publication is for public good. Where the imputation is good, but it is not published for public good, but only for a community, such a publication cannot be held to be good. When the allegations are themselves defamatory and they are not proved over, no question of fair comment will arise. A mere exaggeration does not make a comment unfair. The Bombay High Court has taken the view that defamatory article must be read in its entirely and the court must decide what impression would be produced on the mind of unbiased readers. In Jawaharlal Darda versus Manohar Rao Ganpat Rao, this is the case is discussed in your book and you read this book. Another case, Rajdeep Sardesai versus State of Andhra Pradesh. Sorry. This is also an important case in this point. Now, second exception. Second exception says the heading of this second exception is public conduct of public servant. What is that? It is not defamation to express in a good faith any opinion whatever respecting the conduct of a public servant in the discharge of his public functions or respecting his character, so far as his character appears in that conduct and no further. This is the bare language of exception 2
of Section 499, defamation. Now let's discuss this exception. Any person occupying a public position renders himself open to criticism for his action while discharging his functions from the position he occupies. Such a criticism must be made in good faith and it must relate to action of public servants. Good faith presupposes a reasonable degree of care and caution in making an imputation which, on the face of it, is defamatory. It does not merely imply absence of ill will. In order that the comment must be fair, number A, it must be based on facts truly stated. Number two, it must not impute corrupt or dishonorable motives to the person whose conduct or work is criticized, except in as far as such imputation are warranted by the fact. Number C, it must be an honest expression of the writer's real opinion made in good faith and it must be for the public good. Fair criticism, however, does not justify a personal incentive since an attack on a person's private life is not privileged, but sometimes a private question may become a public one of public is called upon to support it. The whole character of a person cannot be under public character alone involved. It was held in Inri Arundhati Rai case that the broad and general proposition that a reply submitted to a contempt notice can in no case amount to contempt of court in the light of second exception of section 499 and is contrary to the law of contempt as adjudicated by the courts in the country from time to time and the limits prescribed by the act and the judicial pronouncement which are well within the knowledge of all and the all reasonable citizen. Sorry. The law of defamation under the Indian Penal Code cannot be equated with the law of contempt of the court in general. It was further held in the case of Arundhati Rai that even a person claiming the benefit of second exceptions is required to show that the opinion expressed by him was in good faith, which relates to the conduct of a public servant in the discharge of his public functions or respecting his character so far as his character appears in that conduct. Under the law of contempts, statements made in pleadings, petitions, and affidavits of the parties in a number of cases have been held defamatory statement amounting to offences under the section unless it is shown that they fall within any of the exceptions. The benefit of exceptions, even under the law of defamation, much less in contempt proceedings, may not be available if the insinuations are made against an institution of the state and not restricted to person as an individual or a collection of person. Now third exception. Conduct of any person touching any public question. This is the exception third. It is not defamation to express in good faith any opinion whatever respecting the conduct of any person touching any public question and respecting his character so far as his character appears in the conduct and no further. This is the third exception. The conduct of publicist, the person who make publications, who take part in politics or other matter concerning the public can be commented or in good faith in construing a document. The court are not concerned with what the parties intended, but with what the party did and what they said. The word actually used by them and language actually implied. The case of Dogar Singh versus Shobha Gupta is important here, and the facts and circumstances you read with your book. Now, exception 4. The heading of the exception says publication or of reports of proceedings of court. What is said? It is not defamation to publish sustainably true report of the proceedings of a court of justice or of the result of any such proceedings. This exceptions required that the report of the proceedings of a court of justice should be without malice. It should be fair and accurate report of what took place before the court or tribunal. This exception does not require good faith. It is not confined to the judgment and order, but also covers pleadings, whether relevant or not. Supreme Court in Dr. J.C. Ghosh's case said the fourth exception says that it is no defamation to publish a sustainably true report of the proceedings of a court of justice, but does not make any such concession to proceedings of a house of legislature or parliament. The case of T. Satish versus Narayan Nagappa Nayak is important here, and you read this particular case from your book. Now, fifth exception. What is the heading of fifth exception? Merits of the case decided in court or conduct of witness or others concerned. But the provision says it is not defamation to express in good faith any opinion whatever respecting the merits of any case, civil or criminal, which has been decided by a court of justice, or respecting the conduct of any person as a party, witness, or agent in any such case, or respecting the character of such person as far as his characters appears in that conduct and no further. This is the fifth exception. The administration of justice is a matter of universal interest to the whole public. Therefore, a free comment on the judgment of the court, the verdict of the jury, the conduct of party or witnesses is necessary. The criticism must not intentionally assails the character of the others or impute criminality to them. A journalist is supposed to discharge his duty fairly, and if his comments are fair, no one will be permitted to complain. The exception extends justification for a comment on any judicial judgment or decision made in a fearless but fair manner without personal bias, malice, or prejudice. Now, six exceptions. What is the six exception says? What is the heading? Merits of public performance. The peer says it is not defamation to express in good faith any opinion respecting the merits of any performance which its author has submitted to the judgment of the public or respecting the character of the author so far as his character appears in such performance and no further. Here an explanation also attached with sixth exceptions. The explanation says a performance may be substituted to the judgment of the public expressly or by act on the part of the author, which implies such submission to the judgment of public. This is the sixth exception 6. This exception deals with the literary criticism of public performance submitted to its judgment. It covers criticism of book published on literature, art, painting, speeches made in public, acting, singing, etc. The criticism must be fair and made in good faith. This is the essential condition. Now, seventh exception. Exception. Censure passed in good faith by person having lawful authority over other. This is the heading of sixth exception. The law said it is not defamation in a person having over other any authority, either conferred by law or arising out of a lawful contract made with that other, to pass in good faith any censure on the conduct of that other in matters to which such lawful authority relates. This is the exception 7. This exception allow a persons under whose authority other have been placed either by their consent or by law to censor in good faith. Those who are so placed under his authority, so far as regards matter to which that authority relates. The municipal engineer reported to the municipality that the stock of meal was taken away by the contractor. It was held that if the report being made was in good faith, this exception will apply. A statement made by a person during police investigation merely expressing suspicion as to complicity of certain persons in crime will not amount to defamation. The case of Hers Mehendi Ratta versus Maharaj Singh is important here. The plaintiff was the wife of Arjun Lal Mehendi Ratta, who was working as a assistant to project director of Food and Agriculture Organization of United Nations, the headquarters at Delhi. It was alleged that the defendant did not give him any charge of assistance to the project director and instead had been harassing him in many ways. It was alleged that defendant Maharaj Singh expressed the view that he had no choice but to accept Mr. Mehndi Ratta with greatest reluctance, and this statement reflects on the competence of Arjun Lal Mehndi Ratta and as such as is defamatory, causing the mental torture pain to the plaintiff and her family. The Delhi High Court in this case held that the general remark made by some authority regarding the competence of a subordinate would not be amount to defamation. The alleged statement per se, even if made by Maharaja Singh, is not defamatory. It does not reflect adversely on the work, conduct, reputation, or character of Mehndi Ratta or the plaintiff. It was further observed that it is not the plaintiff case that the defendant made any allegation in respect of person's character or moral turpitude against Mehdi Ratta. Now, eighth exception. The heading of this exception, accusation preferred in good faith to authorized person. The bare provision says about eighth exceptions. It is not defamation to prefer in good faith an accusation against any person to any of those who have lawful authority over that person with respect to the subject matter of accusation. The exceptions 8 will be attached if it is proved number 1 that the person to whom the complaint was made had lawful authority over the officer complained against, and number 2 that the accusation was made in good faith. It is necessary for the application of these exceptions that the complaint is bona fide and not made with the intention to injure anyone. A complaint to a police constable is not privileged and will not fall under this exception. A statement in the FIR will fall under these exceptions only if there was good faith of the person making the execution. Accusation in a newspaper is not covered by this particular exceptions. Now, ninth exceptions. The heading is imputation made in good faith by person for protecting of his or others' interest. The bear said it is not defamation to make an imputation on the character of another, provided that the imputation be made in good faith for the protection of the interests of the person making it or of any other person or for public good. This is the ninth exception. Where a defamatory statement is made in good faith for the protection of the interest of the person making it, this exception will come into operation. Interest of the person has to be real and legitimate. The case of L.C. Ranadhir versus Girdhari Lal is important here. This is the very wide exceptions related to advocate, witnesses, or any parties, judges, club members, legislature, etc. What about advocates? In absence of express malice or wantonness or private motive, the advocate is protected under the exceptions 9. The court ordinarily presumed that the defamatory matter was published in good faith and made on instruction. What about witnesses? A witness has no absolute privilege as regard statement made by him. He had only a qualified privilege under exception 9 and exception 1, where a witness is compelled to give an answer in making a defamatory statement, and answer was given on the basis of compulsion. He will take protection of these exceptions. Now comes about the parties. The parties will be entitled to protection under exception 9 if the statement is bona fide and with a view to protect their interest. What about the judges? As I have earlier discussed in third semester, section 77 Indian Penal Code protects the judges for their acts done when they act judicially. Where the judge censors the conduct of a witness in good faith, he is protected under section 77. An action for defamation cannot be maintained against a judge for word is spoken by him whilst trying a cause in court, even though such words are alleged to be false, malicious, or without reasonable cause. What about the club committees? The committee member of a social club, even if wrong, they are given protection under exception 9. But for these exceptions, it would be impossible for such a body to function. What about the legislature? An absolute privilege is attached to the speeches made on the floor of house, either of parliament or a state legislature. Exception to section 499 are very exhaustive and cannot be enlarged. Then what is the difference between exception 8 and exception 9? In exception 8, the person to whom the complaint is made must have lawful authority to deal with the subject matter of the complaint, while under exception 9 there is no such requirement. It would be sufficient if communication is made to a person for the protection of one's own interest along with that of the other, or is made for public good. Now, 10th exception, caution intended for good of person to whom conveyed or for public good is not defamation. The Bear says it is not defamation to convey a caution, सतर्क कर देना किसी को in good faith, सद्भावना पूर्वक, to one person against another, एक व्यक्ति द्वारा दूसरे व्यक्ति को, provided that such caution would be intended for good of the person to whom it is conveyed. उस व्यक्ति को जिसको आपने कासन किया है उसकी भलाई के लिए हो, or of some person in whom that person interested are for public good. For attracting the exception 10, it must be proved that the accused intended in good faith to convey a caution to one person against another, intending for the good of the person to whom the caution was conveyed, or to some person to whom the person is interested, or for public good. The caution is intended to be given to the person to whom it is intended. The imputation must be made in good faith. This is the total section 499. Section 500 discussed about the punishment for defamation. This section says, whoever defame another shall be punished with simple imprisonment for a term which may extend to 2 years or with fine or good faith. This is the section 500 which provided punishment for punishment, and it discussed the quantum of punishment for defamation. Student, you listen and read this particular PPT very carefully.